Member for Watson, the Leader of Opposition Business.
Thanks very much, Deputy Speaker. I move the second reading amendment that's been circulated in my name. This is poor legislation, unnecessary legislation, and for the way it can be weaponised, it's dangerous legislation. At a time where the economy is at the moment and where workplaces are at the moment, there is a reason for industrial relations legislation to be being brought to the parliament. But at a time when wages are flatlining, when the key economic challenge is how do you get wages up, the government's response is to attack the organisations that argue for wage increases. At the time when wage theft is being reported weekly and people are scandalised by what they are seeing happening to ordinary workers' wages, the government's response is to attack the organisations that would defend those workers against wage theft. At a time where occupational health and safety has reached the extraordinary situation where when we talk about deaths in the workplace, we talk about workplaces that kill more than 200 workers in Australia every year, the government's response is to attack the organisations that have always argued for better work safety laws. Now, how do you get wages moving in an industrial relations system like we have? The government will argue, well, what you need is for company profits to go up. Because if company profits are improving, they'll say that's the way to get wages moving. Except for this problem. We've got stagnant wages and wages growing 8 times slower than the rate of profit growth. Wages are growing 8 times more slowly than profits. We've got the slowest economic growth since the global financial crisis. Australia is now in the longest per capita recession since the 1982 recession. The national economy has fallen from the 8th fastest growing in the OECD to the 20th. We've got stagnant wages, rising underemployment and youth unemployment, slowing employment growth, 5 years of weak productivity growth, weak household spending, failing consumer confidence, weak business conditions, living standards growing slower under the Liberals than they were under Labor. And this government says, well, here's the answer. Attack the organisations that would argue for workers' conditions to improve. In fact, it's got worse over the last few days, where they've been saying, here's the way to get wages to improve, just freeze super. Well, guess what? Since this government came to office, they did freeze super. And what have we seen since? Stagnant wages growth. Whenever wage increases come through a minimum wage case, it's not because there's a submission from the government furiously arguing to keep penalty rates or an argument from the government that we need to give a significant improvement to the minimum wage. The reason those hearings, whenever they do result in a wage increase, how you get that is because of the advocacy of the union movement led by the ACTU. But that doesn't automatically mean that it then gets passed through to every award. It gets passed through to the awards because each individual union goes and makes the application for it to be passed through. At every stage in Australia, the way our system works is if unions are strong, if workers' organisations are strong, then the Australian workplace becomes a better place to be in terms of getting wages growth. That's how the industrial relations system works in our country. And let's not forget we have a record number of people now relying on awards. But the response from the government is never, well, how do we make the system work better to deal with the fundamental challenges that we have in the Australian economy at the moment? You see, there was a time when it was at least contestable. It was not my view, but there were at least some people seriously arguing that wages growth was going too far and you needed to pull it back, and they would then argue well, that means we need to attack the unions. Now, where the economic facts are so transparent and the Reserve Bank has been so clear that we need to get wages moving, the only thing that could be driving a bill like this is a pathological hatred of unions. Because it's not in the interest of the economy, it's not in the interest of the workplace, and it's laws that are begging to be weaponised, and I'll get to that shortly. But the legislation that's in front of us at least is consistent with how this government has behaved, because effectively they've had three themes whenever they want to talk about workplace laws in Australia. They have the Registered Organisations Commission, thoroughly politicised, thoroughly discredited. The organisation that decided the biggest issue for them to go after just happened to be something at the time, years back, when the then leader of the opposition, the previous leader of the opposition, had been outside the parliament. Just by accident, that happened to be the one that they wanted to focus on, and then were involved in the extraordinary circumstance where the police turned up after the media had turned up. David de Garis, an advisor to Minister Cash, resigned that night after admitting he'd tipped off the media. Later it was revealed Mark Lee, an advisor to the Registered Organisations Commission, had been about to start a job in Minister Cash's office. He also resigned but denied that he was the source of the leak. And then her former Chief of Staff, Ben Davies, tells the federal court, no, he in fact had been the source of the leak. That's the first of their organisations. The second, of course, the ABCC, the Australian Building and the ABCC, headed by Nigel Hagkis at the time. And why did he have to resign? For breaching the Fair Work Act. For breaching the Fair Work Act. And these are the sort of people they say are the ones they want for integrity. And throughout all of this, for the simple game of desperately trying to get members of the Labor Party and former Labor leaders in the dock in a Royal Commission, they established the Trade Union Royal Commission, headed by the talent at a Liberal Party fundraiser, who, when challenged as to whether or not he was biased, decided there would be a hearing into whether he was biased. A hearing presided over by himself, where he heard the arguments from both sides and then decided he was not biased and went ahead with the Royal Commission. And that has been the way this government has sought to deal with workplace laws. Today is just the next instalment in a ridiculous anti-worker line. And let's not pretend. If you come up with anti-union legislation, it's going to turn out to be anti-worker legislation, because workers will not get the improvements in their conditions, they will not get the pay rises, they will not get the policing for occupational health and safety and against wage theft unless they are strong. And this legislation is about trying every step of the way to attack workers' organisations, to attack representatives on the workforce. Now, unions, of course, are fundamentally different organisations to corporations. A corporation's first job is the fiduciary duty. Their first job is to seek profit, and they have to do that within a competition framework. The first duty of a trade union is to be representative. Their first duty is to be democratic organisations. So the whole argument that the government has wanted to go down with corporate equivalence, we don't accept. But if that is the test, they've still failed it. They've still failed it. And the bill in front of us goes through 4 different areas. It goes through disqualification of union officials, deregistration of organisations themselves, administration of organisations, and amalgamations. And I want to have a look at each of those 4 in turn. The first, and if you hear the government's talking points about this, the disqualification point is the only one they want to talk about. It's the one that they've decided to pin all their rhetoric to the disqualification part, and hope that they can just shepherd everything else through without anyone noticing. And that's how they've argued. Yeah, how many times have we heard them talk about the amalgamation section? the most fundamentally undemocratic piece of worker legislation you could imagine in an Australian Parliament. It basically says the Australian Electoral Commission conducts a ballot and we're then allowed to ignore the result. I'll get to the detail of that. It's extraordinary what is in this bill. But let me start with the disqualification. So this is the one they want to talk about all the time. This is the one where they say they're wanting to make sure that they can disqualify the worst union officials. And the way they've structured this, first of all, is, well, who can make the complaint? And the complaint can be made by any person of sufficient interest. Any person of sufficient interest. There is no clause like this in the corporations law. No clause at all. And you can understand why. Could you imagine company directors finding that anyone could say, I don't think you're up to the job, and could commence legal action, and then they were committed to go ahead and to try to draw on a defence within the Act? The government would never bring that sort of legislation in. The opposition wouldn't bring that sort of legislation in. But the government will do it when it's about trade unions, even though there is absolutely no corporate equivalence in the concept that anyone, otherwise undefined, any person of sufficient interest is able to launch these legal actions. Now, what constitutes then a breach? Because they deal here with criminal and civil proceedings and unrelated conduct. Now, first of all, can I say it is already the case under the Fair Work Act that for union officials there are already circumstances where they can be barred. There already are. They can be barred if they've engaged in fraud and been found guilty. They can already be barred if they're convicted of violent crime. That could already happen. But what happens here is there's automatic disqualification opened up for anyone who is convicted of something that carries a maximum 5-year sentence, even if they're not sentenced to that. So there can be many occasions. Let's go through a simple example. If someone drives without a licence twice, they shouldn't do that. That's why there's a penalty that you shouldn't do that. And the judge might decide in the circumstances they are in, they might have been getting someone to hospital, it might be something like that, they might decide that they get no custodial sentence at all. But they are forever barred from being a union official under this. Forever barred. Sorry, where's the corporate equivalence? There's none. There's none, nor should there be, because it's a ridiculous law. Ridiculous. A technical breach, for example, like not giving the right sort of notice. So you give notice when you're inspecting a dangerous work site, but if you don't give the right sort of notice, so there's an administrative error in how the notice is given. That sort of technical breach, or investigating rampant underpayment of workers, and you technically do it in the wrong way even though you do give notice of it, an application can be made by the very business that you were investigating to say you need to be knocked out as an official. Now think about that. Think about the way businesses are able to weaponise this legislation. If in the course of a dispute they don't have to stick to the merit, they don't have to remain on the argument, but they can in fact simply say, well, I'm now going to go after you. After you. The parallel would be if a union could bring an action under the corporations law to disqualify the company directors as part of ambit within an argument. It's an absurd thing, and you don't have to think for long to see how this will be weaponised by the worst people. And if you want to start with the worst people, start with Jerry Hansen. Start with the donor to the Liberal Party, who apparently, from all the reports, is still a member of the Liberal Party. No one sought to kick him out of their party, but a prominent construction boss in the West. He's been fined more than $60,000 by the federal court for blocking union officials from a building site where a worker had just died. A worker died people went to conduct a health and safety inspection and he denied them access. He's just been fined $60,000 for that. He's a well-known Liberal Party member and donor. He's donated an estimated $175,000 to the federal and WA Libs and Nats over the last 5 years or so. He is a repeat offender. In 2008, he was fined $174,000 for exploiting foreign workers. A decade later, an audit alleged 93 employees were underpaid more than $271,000. That's called wage theft. That's called wage theft. But guess what his punishment is under the law that's in front of the parliament at the moment? Wage theft, taking advantage of foreign workers, denying a health and safety inspection. What's the penalty on him? He's not allowed to run to be a union official. That'll hurt him. That'll hurt him. That's the law that's in front of the parliament right now. It's that ridiculous. The punishment for someone who remains a member of the Liberal Party, who remains cosy with those opposite, who's behaved in this appalling way, the punishment for him, who's said to have a pathological hatred for unions, his punishment is he won't be allowed to be a union official. Well, I reckon on the scale of that, on the scale of things, I reckon that's unlikely to hurt him. I reckon he's unlikely to get too upset about that. But that's the only penalty that comes to him as a result of the legislation that's in front of us. The principles on deregistration in this bill are equally absurd. Now, when people talk about unauthorised industrial action, you can think, oh, sounds pretty serious, unauthorised industrial action. And people often want to go to the most extreme examples. But what does the bill in front of us in fact include? What does the bill in front of us in fact encompass? Unauthorised industrial action includes those times, those of you who catch public transport, maybe those opposite don't, but for those of you who've been involved in public transport, you get different times when private bus drivers, sometimes public, sometimes private, or train drivers, where they go through a period where the industrial action is to not collect tickets. Or where, for example, it would be industrial action if it was part of a campaign in fast food. If a group of workers as part of a campaign said they are now refusing to follow the directive and they will not ask, would you like fries with that? If a group of nurses decide they're going to take unauthorised industrial action by handing out leaflets explaining that they don't think the patient ratios are good enough, and it's not authorised, it's caught under the bill in front of us, what do those circumstances mean? The entire union that they are members of can be deregistered. Now I think, oh, that's a bit extreme. Yeah, it is. I don't know what it's doing in legislation, but it's in front of us right now that those will be grounds for deregistration of the entire organisation. Now, are there defences? Yeah, there are defences. Of course there are. And a judge would have to work that out. But the action can be commenced and the union then gets tied up in the courts, and the only protection that you might think then is, well, as if the Commission would bring an action like that. That's true. Only problem, doesn't have to be the Commission that brings the action. Once again, any person with sufficient interest gets to take the action. Any person with sufficient interest. So it might be the boss, might be the employer, might be the customer, might be anyone deemed to have a sufficient interest. It is a deliberate and calculated attempt to prevent workers from organising. And what's the consequence? And I know those opposite want to characterise your average union member as a bloke probably roughly my height but significantly stronger than me, involved in a blue-collar industry who gets into lots and lots of fights, and that's how they want to characterise modern union movement. Can I say, the typical union member these days is a woman in aged care. That's what the union movement has become these days. Yes, there's still membership in those other areas. Of course there is. But don't pretend that the legislation in front of us affects only those people, because it doesn't. And for the sake of wanting to have an argument over a handful of union officials, this government, this legislation, is looking at fundamentally changing the balance and changing the calculation of what can happen in a negotiation. Because this takes you completely beyond the merits of an industrial dispute. And can I say, unauthorised industrial action doesn't only happen. Some people will hear my examples and say, oh yeah, but they still shouldn't do that. They're paid, they've got their job, they shouldn't be conducting any sort of protest at the workplace. Can I just remind people, the reason certainly in New South Wales we ended up with Sunday trading was because an employer, pretty famous one actually, used to run Norman Ross, now runs Harvey Norman, Jerry Harvey, decided to break the law and open even when Sunday trading was banned, and to pay the fine anyway, because paying the fine was part of the business model, and boasted on radio, I'm making more money by opening the store than I'm losing in the fine. I remember it was a Cogra store not far from me, Norman Ross, when this happened. These are not only examples that will exist within the union movement of the concept of something being civilly, technically banned, but there's an administrative error, or it's something which is part of workers standing up for themselves and trying to get pay rises, or in the case of the nurses' examples, just standing up for their profession and wanting to guarantee better care. Now, if those opposites say they don't want those examples to apply to this bill, then take them out. But I tell you, if you take those examples out, there's not much of this legislation left, because everything has been drafted. It's not capable of amendment to get rid of these sorts of examples. Everything here has been drafted in such a way that it either, if I want to think the best, which I don't really, but let's just work with me, if I want to think the best of the minister responsible for this, they just don't understand how unions work or how this would be weaponised, or, if I want to think a bit more practically, they want to weaken the capacity of unions to stand up for workers. They want a law that can be weaponised. They want a law that increases the capacity for employers in the middle of a dispute to say, you want to demand that pay rise, you want to demand that condition, you want to demand those ratios, I'll show you. And if you don't think there'll be employers who do that, look at Jerry Hansen. Look at Jerry Hansen. It'll happen. It'll happen. Unless either those opposite decide to stand up for the national interest, not holding my breath but still hopeful, or whether in the Senate the crossbench end up blocking this. Because there is no corporate equivalence for this sort of behaviour if that's their test. And if the test is what's the best for the workplace, this thing fails at every level. And imagine if it were the reverse. Imagine if, when Jerry Harvey ran those protests all those years ago to get Sunday trading up in Sydney, imagine if the union had been able to say, we're going to take away your right to run the company. That is the corporate equivalence of what's in front of us. That is the corporate equivalence of what's in front of us. When you get to the section on administration, it's the same story as again. The section on whether or not a union can go into administration. Once again, what's the standing provision? A person of sufficient interest. No corporate equivalent to that. Absolutely no corporate equivalent. Even for this sort of clause, for what's in Schedule 3, even under corporations law, even the regulator can't do what this bill is saying any person of sufficient interest will be able to do. Even the regulator doesn't have the sort of power that they're now wanting to give to any random, so long as it's being used against a union, as long as it's being used against an employee organisation. It's an absurd way of trying to govern. But I think the most undemocratic of all is amalgamations. Now, this is where you have two different organisations and they decide they want to amalgamate. Now, in wanting to amalgamate, what the two organisations have to do is they have to conduct a ballot. Those ballots are overseen by the Australian Electoral Commission. And what the bill in front of us says is even if the first organisation votes majority yes and the second organisation votes majority yes, you can then take that to court to try to prevent it from going ahead. Now, I've got to say, I have had occasions, even this year, when I haven't liked the outcome from reports of the Australian Electoral Commission. You'd all be aware of it. It's part of why I'm on this side of the House. Haven't enjoyed it. But the concept that this House would pass a bill that says even if the Electoral Commission conducts a ballot, you can then ignore it, is phenomenal. And it goes completely against the fundamental principle of freedom of association. Now, those opposite have been really quick to jump and really tough to argue when it's been about freedom of speech, when we've been talking about 18C of the Race Discrimination Act. When it's been an argument about whether someone who has racist views can be really loud, they've been big on the freedom argument. I just wish they didn't go missing when it came to freedom of the press or freedom of association, because they have gone completely missing. How can you get a bigger departure from freedom of association than to say the Electoral Commission will conduct the ballot and you get to ignore it anyway? The Electoral Commission conducts the ballot and you get to ignore it anyway, based on an otherwise undefined national interest test. As I say, the Electoral Commission a few months ago, I would have loved to have gone to the court arguing it was against the national interest. I don't think it really was in the national interest how that AEC decision turned out. But you have to— oh no, you've got another view, I accept that. Yeah, and I accept that. And here's a view, and I'll take that interjection, where it's shared by a majority of the members of both organisations that they want to be one organisation. Why on earth would there be a right to then take that to the court and say it's their organisation, it only exists because they've joined together and formed these two organisations, but we're not going to let them have the freedom of a democratic vote as to whether it should be one organisation? How do you argue that? And shareholders— you missed the beginning of the speech. Anyway, the issue with shareholders, the reason that's completely different, of course, is a company is there to provide protection for investors, in the event that they can't provide their bills. That's what limited liability is about. And because that's the privilege of it, there's a fiduciary duty and competition law that comes in. There's no national interest test as to whether or not there's a democratic process of shareholders here. That's not how it works, because companies at their start, their first role is not to be representative bodies. They're not to be representative bodies. I don't go out to buy shares for some company so that they'll advocate publicly for my interests, but that is why someone joins a union. It's about freedom of association, and the concept that there can be a vote conducted by the Australian Electoral Commission and then ignored by this government has no precedent, flies in the face of the entire concept of freedom of association, and should not be backed by this House or the other House. Look, there are other governments in the world that have laws like this. They're just not the ones we like to be compared to. They're not the sorts of countries we want to be compared to. But for the countries we like to be compared to usually, these sorts of laws don't exist. So whether it is the capacity to try to weaponise the law against individual union officials, whether it's to weaponise the law against the entire registration of a union, whether it's to put them into administration or whether it's to prevent a democratic vote, the legislation in front of us is transparent. The government wants to make it more difficult for unions because unions will argue for pay rises, will argue against wage theft, will argue for better health and safety at the workplace. And they're the principles that this government's committed to get in the way of. Be in no doubt we're not running from the argument on this. Be in no doubt we're fighting every step of the way on this. And be in no doubt for those opposite. When their attack is simply on workers' entitlements and the organisations that argue for them, we will stand up to you.